Alright, I don't like to talk for 3 hours by myself, so please chime in. If you have any questions, stop me, ask me at that moment. I'll try to involve you, but it's a dry subject, intellectual property, so it's not going to be a lot of jokes or fun. It's going to be a lot of law. So with intellectual property, we talk about patents, trademarks, copyrights, trade secrets. So it all falls under intellectual property. So legal definition is intangible asset. But I like to think of it as any other property. Everyone has a car, you have a cell phone, you own a pen, a copy, things. What can you do with it? It's a property. You can lend it to someone. You can sell it. You can license it. You can tell that, all right, you can drive my car, but you're not allowed to go outside property, drive within property, right? You can do all those things with your property. You can do exactly the same things with intellectual property. They just want to make it sound a little cool, so they put intellectual before it. But think of it as a property. Okay? It's intangible. Obviously, you cannot touch it, feel it, but it's just like any other property. So I already said, patent, trademark, copyright. So domain names. Because now everything is online. We all know how expensive it can be to buy a nice domain. The shorter the name is, they sell it for higher. And, so internet domains, the domain name falls under trademarks. So if you are registering you can register your .com domain. I have not filed USAPatents.com, but that's my domain. USAPatents.com. I can trademark it. So in that sense, I'm going to go into each topic deeply, but I'm just brushing over it. If you have any questions, just ask me anytime.
I have a question.
Yes.
What was that? I missed that last part.
I'm going to send these slides to everyone.
Oh.
Everyone.
Oh.
So after I'm done, shoot me an email and just say score slides, and once I get enough emails from everyone, in a day or two, I'll just send it.
Which is, your email is?
That's my business card, but go to USAPatents.com and you can find my email there. There'll also be an email.
Where'd you find it? Oh, up there.
On the porch. Keep talking about, I keep marketing myself. Yes, question.
Okay, so I just want to see if I'm following you. So my website is drkaren.com.
Okay.
Short, sweet, to the point.
Sure.
So what you're saying is that the domain name is mine,
Yes.
right?
Yes.
But if it's trademarked, nobody can have, what would be the
You were getting there.
okay,
You were
what would
there.
be the benefit of trademarking? Because just within the last 6 months, there's another Dr. Karen who has popped up.
Oh, really?
Yes, but she put her last name. However, I've been Dr. Karen for like 14 years now, and I've
Okay.
dominated Dr. Karen.
So
So-
you can file a trademark now, but I'm jumping now since you asked a question. But I'm going to talk about trademark in details. You can file a trademark now. You can say, I've been using this since 14 years back, and see what the trademark office says. If they allow you, your protection goes 14 years back. So you can tell people to stop.
Okay.
But you probably need a lawyer.
Well, at certain point, you do need a lawyer. I like to think it as this way. Like if you have a common cold, you can just treat yourself. Go over to the pharmacy, Walgreens, buy some over the counter and treat yourself. If it's a little complex, you may want to research a little bit before you buy something. And if it's a surgery, you don't want to cut yourself, right? So copyright for me is common cold. I think if you have to file your copyright, go ahead and do it. I generally don't do it unless it's a software related copyright. I tell my clients to just do it so I'll
It
tell
should
them how.
cover all that anyway.
Yeah, I'll tell them how to do it. It's a lot simpler. Unless you're filing a software or it's like a big book or a big publishing company is filing it, then it gets a little complex because you want to protect different avenues about it. Like she was talking about her book and she wants an audio book and so you try to get different aspects of it. Trademark is a next level of the disease. If you do want to do it on yourself, do read it a little because it gets a little tricky. And then patent is a surgery. Do not try on your own because it gets complex. Just drafting a patent and other things, the office will always come back with a rejection once, and then you have to fix everything. I have had cases where I said, dead on arrival, I cannot do anything unless you want me to refile the entire patent on it. There was, I forgot, some online ads out there or ad commercials on TV. I forgot the name. They tried that from patent to file a patent, and I don't know what it was when he brought it to me. Like, you have to follow certain structure, you have to follow antecedent basis, you have to follow the law, not only the structure of how the patent should be, you have to follow the law. I don't know who did it for her and how it was, but it was bad. I would have to charge her again the entire amount to fix it. And still, miss some things because they didn't cover it in the initial patent. So patent is tricky. Trademarks, I think most of the people here are very educated and smart, and if you research a little bit, you can do your trademarks yourself. That's my assessment. Did I answer your question?
Well, I don't want to, I'm sure you're going to probably get into more
Okay.
detail, and I don't want to, I could probably start from a bunch of questions, and I won't right now, so I'll just
All right.
wait. Be patient.
All right, moving along. Okay, there you go. That was the question. Iron
How's it going?
There's no legal requirement that you have to hire an attorney. If you can do it, and I do know some people, like some of my clients, they have filed their own trademarks. Oh, sorry, patents. They have filed their own patents, and they did okay. But it gets more complex and more complex, and so they came to me at later steps, but they had filed their original patent. It was a design patent, it wasn't that complex, but they did need help eventually. So you can do it, there is no requirement that you have to hire an attorney, but if you call a patent office or a copyright office, they'll hire an attorney. So,
Do you know about what I've been told, a poor man's patent?
format patent?
Have you heard of that term?
No, I've never heard of it. It's an expensive process. So getting it back. All right, we'll start with copyright. Okay, so everybody can understand copyrights, right? We talk about copyrights. First thing that comes to our mind is entertainment industry, right? There's a lot of copyright that we have books we publish. You want to file a copyright. But what is really copyright? Like the whole reason you're here is for me to explain you at least the basic differentiations, right? So you do come across something, the light goes on, and then you're like, oh, I may protect it, but where does it fall? Which bucket it falls in, right? So what is copyright? Legal definition is right here.
Yeah.
I'm not
Original
making it hard.
work of authorship.
Read it.
It's original work.
Yeah, so author, that's copyright. If you are author, you created something, you wrote down, you draw a cartoon, right? You wrote a book, you wrote a script, you actually wrote the notes and for the music, you are the author. As long as you manifest it. You put it on a paper, you are the author, and you got a copyright. You don't
have to file
No, absolutely not.
What was the question?
Question was, what was copyright?
No, he asked a question.
Oh, he said that do you have to file a copyright? No, you don't. The second, the fraction of second it takes for you to, touch the paper and draw it, you got a copyright. Yes, sir.
But then shouldn't that somehow be dated to determine so that?
I didn't say you should not do more, but I said the minimum requirement is do nothing. you have a copyright.
How about on a book, when you get an ISBN number?
Yeah.
Okay, can that effectively operate as a copyright?
The ISBN number is just it's just a way of, recognizing which book is yours by a number.
Right.
It does not give you exact copyright. Copyright is a little different than ISBN number.
But there's a date put on the ISBN number, so you know who the user has.
Well, but that's the date of publication, and it takes a while to get to that level. You may have good connections. The minute you think about a book, people may want to come to you and be like, sir, would you like me to publish it? But it may not be the case for a lot of other people, right?
Okay.
So the ISBN number may take a while. So, but the initial question is, you wrote one paragraph, you have a copyright on that paragraph. Unless you copied it from someone else, that you don't, but you do have a copyright. You draw a cartoon character. Now, think about this. Say I have an invisible ink. It goes away as soon as I'm done. As soon as it dries, it disappears. Do I have a copyright?
Technically, you probably do.
Absolutely do. You don't even need for that to stay. It can disappear right after, but you have a copyright. Now, my practical friend here will have more questions to play with, but how will you prove it becomes a difficult question. But technically, do you have a copyright? You do have a copyright.
I have a question about plagiarism. Is there some sort of law about having so many words in concession that constitute, if you take from somebody else's, right, is there a law about how many words have to be?
Well, it's not the law about how many words it needs to be. The law is about distinguishing, okay? If I say, I am a man, I cannot get a copyright. Right? I'm a man. There are a lot of men here, and they're allowed to call themselves a man.
Right.
So if somebody starts, I am a man, that part is not gonna get copyright. You can write it as many times as you want.
How about if you said it came upon a didn't make clear?
Hey, there you go.
Okay, now what
You-
happens with that?
Now you added some more to it. Copyright, it's a scale, right? It's like upstanding. You know it when you see it, right? You will feel it, you will tell, okay, it's at a point where I think I can discern it from someone else.
Right.
So as long as it's discernible, you have a copyright. Is there a minimum requirement of words? No. I can draw a fancy character, that may be just a character. I have a copyright.
Is it true that nothing written by the federal government has a copyright? In other words, if you were to say 407 years ago, I mean,
Say that again.
if you were to, well, maybe that's a bad example, because I was Abraham Lincoln, but, the Constitution, we the people,
Yeah,
okay, that's part of the government's property, right?
right.
Okay, and we as citizens of America have the right to use anything from the government without any copyright.
Absolutely, that's public domain.
Right.
I can copy anything from Patent Office website and put it online. I won't change anything, nobody's gonna sue me. Government is not coming after me, they put it there so you can take it.
Right.
It's a public domain. It's meant for public. Now, some things maybe, government do file, a lot of different departments of government have intellectual properties. If you read recent news, Department of Defense sued US government and won, and they have a judgment against US government because US government was using the technology developed by the Department of Defense and never paid a royalty on it.
Isn't there, aren't they part of the government?
Hey, Department of Defense has its own budget. Yeah.
That's cool.
Are you gonna get into, confidentiality agreements, or let's say non-disclosure?
I do mention it, but always have it.
All right, here's my question. Let's say, I have a few pages, it's a story, and I wanna hire writers, a couple of them ghostwriters, I wanted to turn into
Yeah,
hundreds
kind
of
of.
pages.
Yeah.
Okay, I need to protect myself. How would you go about doing that? You copyright it first, then you have them sign the agreements. This is like work
Yes,
for hire.
do both. File a
What's the-
copyright on it,
What's the process involved and how intricate is that?
filing a copyright.
Well, no, I mean, you have documents that you tailor.
No, just get a non-compete, non-disclosure agreement. Yeah, you can look up, Google it, you don't even have to hire me. There are a lot of non-compete, non-disclosure agreements floating around.
But you should copyright
You
the
should.
original piece.
Yeah, you should. Yeah, you have one page.
How are you
but
gonna
it
get me
can-
work?
What?
How are you gonna get me work? I mean, we're here, don't we
Uh,
need you? We don't need you for nothing.
There's a lot of work. Yes.
Talking about Googling contracts, the one about, that you referred to with him, what about one that would be a confidentiality contract? Would that be similar or different or applicable
It's
to
similar,
different
but
applications?
there are
or-
different aspects to it. It depends in the industry, what is considered confidentiality. You have to define it in your agreement, but non-compete, non-disclosure has a big clause in there which should be confidentiality.
So
If you
the con-
find an agreement online which has no confidentiality clause, you don't wanna use it.
Did you say that again?
If you Google it, you find a template for your non-compete.
Right.
If it does not define confidentiality and what it should be, there should be a clause in there. If it's not there, don't use that. NDA.
Oh, you're talking about the employment agreement.
No, no.
You
Employment,
said non-compete.
yeah, non-compete can be a contractor, non-compete can be a collaborator, non-compete can be an agent.
I mean, if you have people that for hire that are developing characters and scenes and stories,
They're contractors, you better get a non-compete with them, because contractors are treated very differently than employees. So employees you have more bound on them. Legally, there's already default laws that you can use, but it gives contractors a lot more leeway. So intellectual property may belong to the contractor if you don't have an assignment
well, I
agreement.
know it's a little more technical.
Yeah.
You're for hire, but this is like any employer.
Yeah.
You do an experiment, you have an invention, you still are well, even if you're an independent contractor, it's still the ownership of the.
Absolutely. Any other questions? Yes.
The audio book, I wasn't wanting to do it of my book I'm writing, but of the one that was written in 1944.
Uh-huh.
It was copyrighted, and then the man died and his estate kind of disappeared, but it was all given to some university in California, and I've
Okay.
researched that, and it doesn't show up underneath them.
But you cannot get a copyright.
How can I want to do an audio of that. Where do I begin with that?
It's gonna be hard that you get a copyright on it, either on the audio or on the copyright. Copyright, like any other intellectual property, it's an incentive, okay? The Constitution says we want to give people an incentive to develop things, to make new things, all right? New in there is a very important part. If it was not new, you took it from someone, then it's not copyright. You're probably not gonna get intellectual property. Now, when I say new, don't start thinking that you have to be God and recreate everything. No, we all use something that's there, we cannot recreate a new language, we are using English, right? So we are using things that exist, but it has to have some form of novelty. But
I
if
have to
there-
have some form of what?
Novelty,
Okay,
new.
well, it's my voice.
You can try, you may be able to
There you go.
you may be able to protect the sound of it, your voice, but not the content.
How long does the copyright last?
Sorry?
How long does the copyright last?
How long the copyright
Yeah, how
lasts?
long?
70 years, and then you can extend it by another 70 and you can file more extensions.
Is
Oh,
that-
the lot of richest people are dead people.
Yeah, that's right.
Residual income.
No, estates like King or Michael Jackson.
But that's all because of the residuals that they get from that industry.
Those are all residual incomes there. They're probably
Royalties.
the richest artists. Yeah.
I have a question about the procedure for the copyright.
Yeah.
It does cost money, so I've heard something about like you can file an anthology of works and it's cheaper. Like
Say that again?
okay, like if you have more than one piece of work that you want to copyright, it's gonna be expensive to do each one individually.
Right.
So I was told like you can put them together.
Absolutely.
And it's called an
Absolutely.
anthology or something
Who-
like that.
who was
Is
here-
Is there a common factor that has to connect them together for you to do that, or you can just do
No.
anything?
Someone was here talking about
Hodgepodge.
video game or developing a video. Right. So, like, you don't have to file each screen capture as a separate copyright. You can create a catalog and file one. Right? Now, instead of paying $60 every time for each copyright, you pay $60 and you have a catalog, like a book. You can say
Oh.
copyright.
Okay, I have a copyright on my board game,
Okay.
and
Well, I'm
and I
talking
have,
about software, you know, software, the screens change.
okay,
You wanna be able to protect, you know, different background, different screen of you, what you're doing. So the idea being, what she's saying is that, do I file each screen or each page as a separate copyright, or can I be joined
Com-
together?
okay.
You can join.
Okay,
Yes.
there was
Okay,
a
that's
question
fine.
to the question. Does there have to be a common thread to connect them together, or can it just be a hodgepodge of things that I just like how it's okay? So I can just
Yeah.
group anything?
Modern art is copyright, is there a common thread?
Yeah, that's true.
All right, any other questions?
I have one question.
Yes, sir.
On my online wagering part of my game, it says up here, it says, okay, perform the work publicly. Now, my idea of that would be is to videotape people playing my game, let's say at a sports bar.
Okay.
And I could use that as part of my protection for my
Yes.
online wagering.
That video is yours.
Okay.
A picture taken off a natural scene, I have a copyright on the picture. It's my artistic work. The angle I choose, the lighting I choose, the day, the time of the day, the different aspects go into photography. It's my artistry. It's my thing. No one can come in and take that picture and be like, it's mine. They can take the picture of the natural scene I'm taking. Yeah, they can have multiple photographs of the same thing, but they cannot use my photograph. Okay, that's why artists have some value. Yes, sorry, yes.
I'm not sure what this is gonna fall under, so I'm just gonna throw it out there. I have, Dr. Karen Health TV was created for me.
Okay.
And it's about prescription privileges, health education, and veterans benefits.
Okay.
And I'm a vet as well. And I have over 200 hours in bits and pieces that were supposed to go on this. And the guy who actually shot the video said, no, this is mine. So
Did
it's,
you have a contract with him? Assignment? It's his, sorry.
why? But it's my work. It was my ideas.
Photography belongs to the photographer, not you. I had a recent case where I actually, one of my close friends, like family friends, their family, like one of the members wanted to do modeling. And then they did modeling and they had photographs that the artist didn't worry about and put it online. And now they were really worried. They're like, I don't want these pictures to go up. It was supposed to be private. I wanted to have some photographs. I want to have my profile. I'll show it to whoever I want and I'll take it to different agencies. So they came to me for help to get those pictures off. I mean, eventually I was able to help them, but the copyright belongs to the photographer.
Most
That was
times,
the first thing I told them.
most times in those scenarios, I've been on the other side of that, you have to, the talent signs a release.
Every photographer who has some experience has a release form,
Oh, yeah.
and he's right. Even if they don't have a release form, technically it's their picture. I made myself available. I can be walking on the beach and somebody takes a picture. Doesn't matter. It's their picture. So, as I was telling him, very important that the contractor you hire, you have an agreement in terms of assignments. You need to have assignments.
Guess that's like the paparazzi taking pictures of people and then they want to sell them to the Star or the Inquirer.
Yeah, all stars are a little different. Stars are a little different. Law treats them a little different.
Then the National Enquirer? No, I said,
Unless
to
it's
the
slated.
National Enquirer, like they'll want to
Yeah,
sell.
if well, there are some pictures that can be okay of a celebrity. Some pictures are not. Okay, celebrity by definition is person who is making money based on their.
So they're treated differently.
There
than the
is
general
some
public.
law that protects them more. I am not a celebrity. So if everybody wants to take my picture, I'm walking naked on the beach, they can take it. I cannot do it.
It'd be dangerous to people, huh?
It is the law. Yes.
But with regard to the other gentleman who had the game, wouldn't he be better off and
careful if he got the release of the people who are in the picture that he's taking?
Yeah.
It'll be nice, it's always good to have multiple layers of protection.
Yeah, I know that
But-
isn't necessarily IP, but,
No, it is, absolutely, those contracts are intellectual property.
but I mean,
The part of intellectual property is not just filing, it's the contract part for defending and making sure that
Right.
whatever work you do, it does not go into public domain, or, you know, other laws are protected by it,
Right.
or you don't lose like she did, now that without
Right.
the videographer is not giving her the movies back, so, you know, it's
yeah,
part
but I
of
was thinking in
intellectual
terms
property.
of, so then he wouldn't get sued, but people, you know, like somebody, if he,
Oh, that's release, I think you're
That's what I
talking
said.
about release
That's
and assignment.
yeah, no, I said release.
Yes, yes.
And Dr. Oz obviously is a well-known celebrity.
Okay.
All right, he one time on one of his shows said something that I very much agreed with, and I wanted to show that in the video that I made up. I'm
Can
not,
I use Dr. Oz?
I can, even though he's a celebrity.
Yes, that's why you cannot, because he's a celebrity.
That's why,
You cannot say Dr. Oz said this, or Dr. Oz agrees
well, I'm
with
not
it.
saying it, I'm showing his actual image that he's got posted on YouTube.
Mm.
You know, YouTube content is either owners, and YouTube has, or Google has an exclusive license to it. So if you're not directly getting it from the owner, permission to use it, you have to go through Google or pay Google royalty. Okay? Yes. Sorry.
One more question. I had a co-host for my show, and, she's not involved in the process anymore. And I have a lot of other things that were taped that were not by the individual that I was talking about. So, are you saying that I have to get her permission because she was a co-host on my show? In
Well,
order to show these?
it's a more complex question. Depends on what it is she's doing in there.
Basically,
If
we're
she's
talking-
hosting it as like you, is she making herself available? Was there any compensation involved? Did you compensate her for
No.
anything? Was it voluntary?
It was voluntary.
Can she come back and say like, oh, now she's exploiting me commercially, I want some money from her? She
Well, we
probably-
were basically talking about domestic violence, our experiences of working with domestic violence.
No, the the videographer has the videos, it's his. So-
No, I have all these.
Oh, you have all them, then it's yours, if the
Okay.
videographer gave you all the rights. Yes.
What is meant by the statement of non-confidentiality and non-use?
Statement on non-confidentiality and non-use,
Yes.
I guess it's opposite to confidentiality and use. You just, like, you're trying, where are you getting this from?
Okay, I contacted a company called Invent Help.
Oh my God. I have, in last 2.5, 3 months, 7 people come from Invent Help, it's a scam.
Okay, that's why I didn't do it in business with them.
Don't.
What is this called?
It's called,
Yeah.
it's called Invent Help.
Invent Help.
What is it?
And see,
They talk about, they use the word invent, and people think that my invention will be helpful, but they are purely marketing company. They don't file patents, they have this hookup with another attorney who does patent search, and he does his work right. I'm not saying he's doing anything wrong, but they do a search, make you pay for it, and then that's it, and then they start telling you to give us the rights to market for you, but they never tell you to protect your idea, and they charge crazy amount of money.
Okay.
Yes, maybe up to 15, I have heard stories being asked for $25,000 to market their product. It's a big scam, be careful. Unless you have protected your idea, do not go to Invent Help. I don't know if they really can market you, but they will never tell you to protect it, okay? Be careful. I have had, seriously, I've had, last 3 months was just every other guy walking into my office was from Invent Help.
Your
I had
instincts
2
and
books,
intuitions.
one patent search and one, it was, yes, it's crazy.
What is the penalty if you were to take something off the YouTube and use it? What normally, I mean, okay, so you're guilty for stealing somebody else's intellectual property, okay. Well, what usually happens is
They can send you a cease and desist letter
Right.
to stop, and they will ask you to pay some amount for it, for using it, to settle it, otherwise they'll take you to court.
Don't they have to prove certain damages?
Yeah. But damages
So
is
basically,
copyright, it's
so
my
you
copyright.
weigh, so this is one of those laws you weigh out, how much does it cost to break it? Let me decide. Some people go.
Every law is like that.
Not every law.
Oh, yeah, absolutely. Ask anyone.
No,
You may not break a criminal law, but ask a criminal, he'll be like, yeah, you know, let's deal with it.
Well, some I'll pay more taxes, it's worth it, I'll do that.
There you go.
You know,
You just-
it's
you
all
just
about
did.
consequences.
How about logos? Is that on the copyright? Like if you have a logo for this?
Logo depends, logo generally falls under trademark,
And
but if the artist who is making the logo, get the release from them so that they don't claim, oh, it's my copyright, I didn't get compensated or blah, blah, blah. And everybody gets some form of release. And if they don't, and if it's years have passed, it's an acquiesced, they've acquiesced that they've given you something, so.
And also, like the name of your business, can you copyright that?
Trademark.
Oh, yeah, that would be
Yes.
trademark.
Anything that you relate to your business falls under trademark. We'll get to that. All right. Any other questions? Can I move forward? All right, one more.
Computer code?
Copyright, yes.
Okay.
Yeah, the requirement is that you, if it's very long, which most of the codes are supposed to be, you protect the first 50 lines and the last 50 lines. And you put it in there as a copyright. You can submit the entire code in a CD or DVD, but that's the minimum requirement. Questions? All right. All right, so what are your rights? You're a copyright owner now. You file a book, you drew a cartoon character, you have something. Well, what are your rights? These are your rights. You can make copies, right? You can, like if somebody's making a derivative work of you, if somebody's making a movie of his book, it's yours. It may be a movie, but it's based on his. So they have to get his approval. Like you said, you want to voice the book. The book copyright belongs to someone else. You cannot start voicing it and using it for anything commercial unless you pay a royalty for copyright. Distribute the copies in public, right? We talked about like your car. You can sell, rent, lease, lend. You can do all that with any of your copyright, or basically any of your intellectual properties. Perform work publicly. Again, this comes under performance. You can show your audiovisual. You can go and talk about your book or read your paragraphs of your book anywhere, right?
You said something about writing. I just wanted to clarify something. This is in terms of writing, like a book. Like, suppose you're writing a book, but it's like a continuation of something that was already published, and you're using that as like a reference point or like almost to connect it to it. Is there any? Do you have to get?
You're writing the 4th volume of Lord of the Rings.
Okay.
You better contact for
okay.
license.
Alright.
They're coming after you.
Okay.
Yes.
Alright.
Display the work publicly. You have art. You're a world-renowned artist. You have a nice picture. Nobody can use it in their gallery unless they have permission, or any other public demonstration. Perform work publicly. This is again like just this section of the law is very specific to TV broadcasts. So I'm not going to go deep into integrity. Right? Let's talk again about the book. The movie is being made. He can tell them, I will not give you my copyright, or I will not let you make my movie if you change anything in my book. And they'll throw $1 million more and he'll be like, whatever. But he has the right though, to tell them to stop. Nobody does. But he has the right. All right? Practical versus theory. All right? Any questions?
Yeah, how about if you take a very famous artwork, like Grant Wood had American Gothic with, okay. And I have seen many different copies where they'll change the faces and everything else. Is that infringing on their copyright?
It's a very close call. Most of the people get away with it because nobody's gonna come after them.
Yes,
Okay.
Grant Wood is dead.
Yeah. Plus, it's been a while and nobody's, I don't know, it's state or how much they're making money right now.
Right.
But then again, there is something called, I am not the expensive brand excuse. You can tell that I'm not Fendi or Coach. I'm a cheap guy. I'm making sure everybody knows I'm a cheap guy. Everything is cheap. Nobody will ever confuse me with that.
Right.
So they may be getting away with it. What if they don't have money? What are you going to do? File $1 million lawsuit to collect what?
Yeah, right. Deep pockets.
Yeah.
It's like some of these shows where someone, the co-host of the show has a birthday. They can't sing happy birthday because they're going to have to pay a fee for it, but we sing happy birthday in our own homes and we don't have to pay a fee for it.
Probably. Any other questions?
Is there really a copy on Happy Birthday?
Yeah.
There is?
You're kidding.
They're coming after you, but if you were on a major broadcast network or a
Well,
local channel.
public performance has as a legal definition, public. Okay, this is public performance. I am doing public. The slides, all of these are mine. Legally, when I signed up with SCORE to be a mentor, it belongs to SCORE. Okay? If they ever want the copy, I have to provide them with a copy. But it's all mine, it's all my work, it doesn't matter. I signed the contract. So, public performance is public. You can buy a DVD or rent a DVD, play it at home. But you cannot have like, all right, let's get together in this public park and we'll have the neighborhood come over and we'll watch a movie. You cannot do that. That's public performance. I mean, I'm not saying, people have done it and nobody's a thief unless they're caught. All right, moving on. All right. Let's see. Again, who can claim copyright? Authors. Only authors. You can sell it. You can have the exclusive right. You can buy every right they have, but only authors have copyright. All right. Work made for hire. Since he's already asked and I've answered, it's probably a new topic, but make sure you have your contracts in. Do not. I will be sending all the slides.
Oh,
Yeah, don't worry
I
about it.
have no interest.
If you like my, no problem if you want to post it on Facebook, but I will send all the slides. Work made for hire. Be very careful. Contractors have the right to hold their property back. The court is theirs. The video is theirs. Photography is theirs. A contractor means no bounds with you. You're just hiring a mercenary. It's his. Okay? Employee becomes different. Yes, sir.
You actually see intellectual property agreements titled that way. Do you see those separately?
Yeah, absolutely.
Released separately?
Yeah. Why?
They're harder to find than.
I didn't say everything is on Google. I wouldn't get paid for anything then if everything was on Google. No, plus as it gets more complex, you don't want to use the Google part. You want it to be, like surgically done for you. For simple. Yes.
If I'm doing a video demonstration of my particular online wagering game, everybody that's in that video that I'm going to use for demonstrations, do I have to list them as a contract or get some kind of contract signed by
Get a
them?
release from them.
Get a release from
Yeah.
them, okay.
Yeah. Don't, just be careful. You never know. You start making, nobody's gonna come after you unless you make money,
Yeah.
right? You don't have, nobody has enemies. The poor man has enemies.
That's
As soon
it,
as you
like-
make money, that's where we come in, because we don't work for you. And if you have money, the first thing an attorney tries to find out is personal injury. I do some personal injury work too. I don't go after anyone who has no money. Why would I? I don't have time. The only reason people come after you is so that you have money. So protect it now, so you can be, free of tension later. Any other questions? All right, authors of joint work, they are co-owners. They have equal rights unless there is a contract which says, although you're working with me, but you're only gonna have 10% right or 5% right. If there was no contract, 50%. Both individually can license it, sell it, do anything with it. Well, that being said, they do have to give you your right or your equal amount of money back. They're getting royalty, they cannot pocket it. But they can sign a contract and be like, oh, go. They can sell it to your competitor. You will have to respect the contract, but they will have to give you the 50%. All right. All right, another question is, oh, I sold the book, I sold a copy of my book. Did I sell my copyright? You buy DVDs. You don't have a copyright in it. Just mere sale of that object does not give you copyright. The owner still has it. You only get an excusable use because you bought a copy of it. You can do anything with it. You can watch it, you can burn it, you can destroy it, you can do whatever you want with it. It's your copy. Okay? You can sell it again. But you don't have a copyright on it. So now when we talked about the rights that the copyright owner has, you don't get any of those rights. You just merely got a copy. So be careful about it.
So
Yes.
like you're talking like, when you see these websites where they have people who write for the websites, write content, and I guess sometimes the writers don't have the copyright, depending on, I guess, the agreement that everyone is signed up. But for somebody who's like a freelancer and they're submitting a piece of work,
Better have a contract with them.
and so how does the first rights, because I always see something like first rights or whatever, I guess they own the copyright on, they own the copyright, but the person who's publishing it can only run it for like a specific amount of time and then.
See, the thing is, like, their publisher contracts are just,
Also,
there's a lot of variation.
also depends
It's a
on.
world in itself.
Okay, so it just
Okay.
depends on what it is.
And you can do whatever you want with a contract. You can do whatever, you can slice it any way you want in intellectual property. So, I mean, I can go into the, but the publisher, I can go over the entire day, but I may still not cover the topics. So individual, you can come over, you can come and talk to me, send me emails if you have specific questions. All right. All right, so what is it that you cannot copyright? The simple understanding of this, but when I send you the slides, you can read it again. But just to give you a simple understanding of it. Law in itself is trying to separate these entities, copyright, trademark, patents. So what it's saying is, it falls under trademarks. You cannot get a copyright. I don't try to do copyright. It's an idea. You're not gonna win the true nature of your rights by copyrighting an idea. You better file a patent, okay? Idea is in your head. You didn't draft it. You don't have a manifestation of it. So those are the main things you cannot copyright. And always, if something is in your head, you never wrote it down, there's no copyright. So the most important thing is authorship. You have to have a manifestation of whatever you were trying to copyright.
While you're doing that, quick question.
Yes.
Why is it important when you get a copyright, you're supposed to take, put a copy of whatever the material of the book, etc., and put it in a sealed envelope and don't open it? Is that's in case?
Or you mail yourself.
Yeah.
Yeah, you send a mail, registered mail, do it registered, send a registered mail to yourself with that, whatever your copyright is in it. So you have an actual date if you don't want to file it. That's poor man's copyright.
How
There's
about
no
an
poor
email?
man's patent.
An email, is that any good as well?
If it's an electronic version of it, you can email yourself. Yeah, absolutely.
Well, good.
That's for copyright, you said?
Copyright.
Cool.
You can do it for anything, it will validate the date, but then other aspects of the law you still have to prove. So you're not getting a patent on it unless you actually file a patent. You can draft an email, you mail yourself, and nothing's gonna happen. Somebody else will file a patent and you will be like, I have a mail, keep it. What else?
I'll see you in court.
No, no need. You can go to court, do whatever you want, I have a patent. What else? Any other questions? All right. So, do I have to register a copyright? Again, no. You don't have to register a copyright, okay? Copyright created as soon as the ink touches the paper, you have a copyright. Okay, advantages, all right? If you do register a copyright, you have put the rest of the world on constructive notice. There is no excuse then. I don't have an excuse by saying, hey, I never looked up on the copyright register to see if somebody had a copyright. That's not an excuse. I have a constructive notice. What does it mean? Money. Your damages start from the day, whichever is earlier, the day you file a copyright or the day somebody starts using it. If you have constructive notice, you get your damages from that day. Okay? And if you can prove willfulness, you get 3 times, treble damages.
Where do you file for a copyright?
I'm going to get you.
Okay.
Next slide, Rob. All right, the really big advantage of filing a federal copyright, and I'm talking about federal, not state copyrights, sorry, okay? Filing a federal copyright is that treaty. There is something called Berne Convention. There is something called Berne Convention, which says that you may have copyright in one country, but you can always extend it to another. And you will get the date backdated to when you actually file in your country. Very big advantage, very big advantage.
That's for federal copyright?
That's for federal
So it
copyright.
extends worldwide?
Because US is part of that treaty among the nations, so all the.
That's what it looks like.
Oh, that's the Berne Convention.
Yeah,
There you go.
that's what it looks like.
Yes.
So, if I create an ebook, and I'm gonna be sending it out to, I mean, I've got contacts all over the world through LinkedIn. And so if it goes to Iran, if it goes to Romania, Norway, Sweden, as long as I have the federal copyright, then it will protect the ebook.
Yes, it will. But you have to register in Romania, wherever you actually will have to go there and file a copyright under Berne Convention.
In every country?
Yes. You have to pay their fees. They have no loyalty to the US.
So how many countries are in that convention?
Anywhere you want to do business. Trust me. You have to file a copyright in their country. That's they're giving you a big incentive, but you have to pay money there.
Do you have to do it within a certain amount of time?
Not for Berne.
You have to physically go there?
You can file it electronically.
Okay.
It's internet age. You don't have to go anywhere. Questions?
How do you spell that? That convention?
BERNE.
R-
B for bat, E for elephant.
But what if it's like a song and they're over there stealing it out, you don't have to go.
Listen,
How does that
don't,
apply? You gotta go, you
like,
gotta go.
I get this question, a lot. All right, oh, in China they're stealing it, or India they're stealing it. They're stealing here too. Everywhere they're stealing.
But you have to go around the world paying fees, every
Yeah,
country. you
absolutely.
protected.
Well, how would you get,
I didn't know that.
how would you go after anyone if you don't have it registered here? Right? You have to file it. There are laws in China, there is laws in India, there is law in every other country, Thailand, which is, or Hong Kong, which is the biggest producer of pirated softwares. There are laws. If you have money, you can fight it. But you have to go respect their laws, file it there, so you can pursue.
Can you spell that again? B-E-R-N?
BERNE. I don't have it here.
Berne Convention, what it's called?
It's coming up on the slide.
It's a city in Switzerland.
Yeah, where the final meeting took place and the essence of it was signed.
Since you mentioned China,
Yeah.
let's say for instance, a lot of companies now, from my understanding, if I want to mass manufacture a board game, and I get a contract for the Chinese to make them for me, do I have to get a patent still through China?
You should file a patent there.
Okay.
It's a big industry, intellectual property. Respect their laws. I mean, at the end of the day, it all comes down to the money. Can you go after someone? That's what like big companies do too. I mean, it's not like, it's always a, profit loss analysis. It's
David Gold.
the cost benefit analysis.
So Coach did, the flea market, they got 1.4 million to settle per purse.
Yeah,
They sued,
Mhm.
they sued
Preston Hen.
Preston Hen.
Yeah.
Flea market.
but there was money, right?
Yeah.
$1.4 million. That's why they did. They're not gonna go after
They
someone
set an
who makes
example, too.
$1,000 a month.
But he wasn't selling.
No,
That's
he
what
wasn't
I'm-
personally.
And you're gonna prepare.
Who's aware?
Some,
This guy know
some,
what-
some
know
are
his
more
property.
tighter than the others, but it all comes down to, there was a case a few years back where this student from, I forget which country, Philippines maybe? I'm forgetting which country he was from. But he came here, again, I'm not sure about the university, but I think it was Cornell. He came here for graduate school, or undergrads, and he figured like it was way expensive for him and he can sell the books. So what he did was have his friends, family send him the paperback books from Philippines. And if I may be wrong on the country, but wherever he was from. And over the years, he actually made millions of dollars. He figured it costs him pennies to get those books here, and they cost a fortune. So he did that for 4 or 5 years. The case went all the way to Supreme Court. Yeah, they took him all the way to Supreme Court because they made millions. He became a big industry.
Like deep pockets.
Yeah, he got very deep pockets. He did not do anything what he came here for in terms of his education. He just was a big business. So they did get to him after. But the law is the first use, or exhaust. So means if you, in terms of the book, the property was his, the copy belonged to him. He didn't sell anything else. He bought a copy and he sold it. Supreme Court said, what am I gonna do? Is that not the law? Now they changed it. So, but that's how, everywhere copyright works. But whoever can play with it, but if you don't have money, they're not gonna come after you. Yes.
Given the fact that if you don't have money, they won't come after you, could they go after you criminally?
What are you gonna get?
No,
Yeah,
criminal
absolutely.
prosecution.
There are RICO claims filed for in copyright. Under RICO statute, there is an enormous copyright law. Not a whole lot of people know that, but there's a RICO statute, and RICO stands for racketeering and criminal. But in copyright law, it's a criminal offense, and there are RICO claims. You can Google. I think I forget very big stars. They've been sued by federal government for under RICO law. And yes, you're right. But then there has to be an incentive, right? The federal government also does profit and loss analysis and cost benefit. Everybody's doing cost benefit analysis. If it gets to a point where it is, screams out and it's wrong, people do take care of it. But you're right, there are criminal offenses for intellectual property. Oh, that's the resource you want to look at, copyright.gov. That's for copyright. If you go on there, it's a very simple website. Create a login, and it will tell you very simple steps. I think 4 or 5 steps where you can just file your copyright. All right, moving on to trademark. Again, like copyright, what is trademark?
Anything used by owners to identify goods and services.
There you go, sir. Awesome.
Hire him.
Trademark, right? I wrote the word trade plus mark. So the very,
Goodwill of your business,
sorry?
goodwill of your business.
Well, that comes eventually, but that's what you're building. But trade is one part of trademark. Means you're doing something in trade. You stream of commerce. That's what it means. If you're in a stream of commerce and you have a mark, and again, trade and mark are very liberal words. you're doing something in a stream of commerce, you probably can file a trademark on it. Okay? There are different kinds of trademarks, but that's the essence of it. Now, how does it differentiate from copyright? A big difference. I am author. Okay, I'm doing business. I'm an author. As soon as I write something, I have a copyright. But when I start doing business, logos, name of magazines, domain names, colors, schemes, how it looks, feels, everything falls under trademark. They're not copyrighting.
Sometimes you have to have both, depending.
You have to have all three.
Yeah.
And then the fourth one, which is trade secrets, you keep some secrets. Everything is involved. Okay. So what, like I already said, goodwill. The trademark, you can file a trademark today. Again, but what is it that you're really doing with your trademark? You're building a goodwill. You're building a brand, right? That's what it eventually will have some economic value. If you build a brand, if you build the goodwill. So you protect it today, and then you work on it, and you market it, and people know your name, and they know, oh, Apple or McDonald's. Think about it, if Apple has to change today to orange, how much money they have to spend, right? It's a goodwill, they built it, they have a brand. You go to a store, you can tell the walls are steel with some fancy white color, like blue shirts. That's all trademark. I cannot have a store with steel walls, white colors, and guys with blue shirts walking around. I cannot. It's a trademark. It falls under another subset of trademark, but it's a trademark.
What if you're selling something else? Not,
Doesn't matter.
if you're selling fruit, vegetables or
That's
something?
great.
Maybe.
How about, my last name is McDermott, and if I was to open up a restaurant, could McDonald's say that I'm infringing on it?
McDonald?
Yeah.
That's too far.
Personal names.
McDonald.
McDowell.
If you put just ED after it, you're going down, sir.
Yeah.
You better close the restaurant and run. They have an army of attorneys. They will descend and just take every penny.
How expensive are trademarks in comparison to copyright?
Trademark is a little more expensive, just the fee itself is minimum $275 for each class. There are classifications. You have to tell which trade you're protecting this against. Like he said, if I'm selling vegetables, you can have an Apple store selling vegetables. But I'm just saying in theory, they're gonna still come after it.
Depends on how much money you're making.
Yes. But you have to classify what trade you are in. So I'm a service industry. My law firm's name is my last name, Kular PA. It's a service industry. I'm not producing anything. If tomorrow someone starts selling T-shirts under Kular PA, I cannot go after them. I have no connections with them. They can have a trademark.
But if you got a trademark and the other, like McDonald's thinks that you're still kind of infringing, but you've got trademark.
And they'll find a way to come after you if they
Still in
want
it.
it. That's the point. They are too big. It's not a good example.
Not fails.
Like Apple was not a good example. But the law is that if I'm not in the same class, the law is actually a natural expansion. If you are doing something which has a natural expansion into other classes, I can protect those classes. Okay?
What would happen if McDonald's has the McRib? What if Burger King called it the King Rib? It came out with King Rib or something, right?
It should be fine.
That-
They're
we can
both
do that?
equally powerful.
Ribs not.
They'll figure out.
I mean, if they find out McDonald's is selling a lot of McRibs.
There's
they
never
say-
gonna be a war between US and China. They both have that.
Yeah,
So
right.
there will never be a war between McDonald's and on something so small. Yes, Apple and Samsung are fighting, but
Yeah, right.
it's more emotion than actual real substance. Go ahead. Any other questions?
Is there a difference between trademark and service mark? Because the Florida
Yes.
statute probably does
Yes.
distinguish between the
Yes,
two.
I'm going to get to that. There are different subcategories of trademarks. Questions?
Monopoly game, are you familiar with that?
Yes, sir.
Okay, the Monopoly has a trademark, is that how they protect the game?
They have a lot more than trademark.
Okay.
They have trademarks, they have copyrights, they may even have method patents.
Have what?
Method, means they're protecting the process of how you play the game.
Oh, what's that called again? Method? Okay,
We'll get to it.
okay, I'll wait till we get there.
All right, trademarks. You just asked me a very good question. All service marks. They all fall under trademarks. If there are trademarks, there are service marks. Certification marks are you get your degree. You know, there's a certificate. There's a certification. Collective mark, a little less like organized structure, but group of people can get together and have a collective mark. And if you are part of our group, you can use it, like gangs. That's a collective mark.
I'm sorry, like what?
Gangs,
Yeah.
motorcycle, bike gangs. Those are collective marks, all right? Trade dress is what I was talking about in terms of Apple Store, right? The entire theme is also trademark, right? There was a very famous seminal case called Topaso versus Taco Cabana. Those two Mexican restaurants were going at each other because one thought that, you know, they built this theme around theirs, and which, you know, they had some differences, not a general any Mexican restaurant you walk into. And then there comes another restaurant which kind of built exactly like that. The tablecloth was the same, their menus looked the same, their walls were painted in the same shades, and there was a lawsuit. It's a very seminal case. Every element of trade dress comes from that case. So, you know, trade dress is a big aspect. So we were talking about vegetables. You know, yes, but Apple is too big an example.
What I meant, like if it was something totally different, not
Yes,
anything to do with
different
electronics
classes.
or anything like that.
It's a different
Like
class.
if you sold T-shirts or something, and it's the same
Right.
colored
Right.
store.
If it's a different class, you don't have to, you are protected. You can file your own trademark in that class and use it. Like I said, I'm a service industry. I'm not T-shirts.
Like Publix has black pants and green shirts, their employees. If I
Right.
had black pants and green
That's
shirts and sold.
that green color is a trademark. You cannot
But-
get that green.
But if I sold, cell phones, I opened a cell phone store, I'm selling cell phones and wearing that same attire, it's not
Cell
that.
phone is too close a class. You see? Cell phone is too close a class. You're selling again. Change the color. You're not gonna color. Change the color.
Black shirts and green pants.
It may work. Kids won't like wear it, but it may work. Yes.
Well, you say like, the colors in the dress, I mean, there are like, McDonald's has, their yellows are, their specific yellow, their red is their specific red, I mean,
The
right there,
shades, the
it's,
shades of
yeah.
color are trademarks.
Yeah.
You can trademark the color. Yes, we cannot use McDonald's color. You cannot use that arch. Be very careful for any arch you use. Yes.
And even the noise of the motorcycle,
Absolutely.
Oh, yeah.
is
Absolutely.
Harley
registered.
The slogans, the noise, the sound,
That's
you know,
what Harley Davidson,
like you
Mhm.
hear,
Remember that?
you know, the bells, the whistles,
Uh-huh.
all those fall under trademark. They have protected everything. So everything
There's
is
got
trademark.
lawyers.
You know how much intellectual property is in a coffee cup? You go to Starbucks, you buy a coffee, the lid is a patent, the cover that protects from heat is a patent, the cup is a patent, there is a trade secret in the coffee, they're not gonna tell you where it comes from or the blend they use. There is so much intellectual property just in one cup of coffee. So there is a lot. The sleeve is a patent.
Mhm.
So every other day there is a new patent they file on a different kind of sleeve, but.
Now, if say Dunkin' Donuts wanted to use that sleeve, what would they do? Go to Starbucks and say,
Go
we'll
to the
pay you?
guy who has a license, you can go to the owner of the intellectual property. Most of these are not owned by the corporations.
Oh, I see.
Some of them are owned by individuals. They make good money.
So you could pay them a royalty to use that type of sleeve.
Absolutely. You start manufacturing your own, go to Starbucks, be like, you wanna use my sleeve? Yes, ma'am.
The same guy that I told you about that took the 200 hours, he created trailers to start the programs before, you know, I went on. Can I still use those because he created those for me? Or, because I have those,
Okay.
because there's music in the background and he has designs and things. So
No.
I can't even use that stuff,
No.
even though he
He
created
created
it
the
for
trailers.
me.
Sorry, I know where you're coming from, but that's the law.
Isn't there anything I can do to help
Go to
you?
the guy and buy it.
I'm not kidding you. I'm not kidding.
Hire him.
Yeah.
Go buy it. Can't you go buy it from him, pay him something?
Yeah, you can tell
The
them.
problem is, he won't answer, I mean, he screwed us with our other business as well.
Maybe you don't wanna do anything with him anymore.
Hire him.
Hire an
How about
attorney.
negotiate?
Private detective.
Right there.
Yeah, hire him. There's a private investigator here. Who's a private? Oh, there you go. You have a private investigator.
I know where he lives, I know his phone number, he's not answering anything.
You want his legs broken?
Our websites, or my TV show,
Right.
or anything, just gone.
You know, it's better safe than sorry, and applies in law every day. I've seen bad cases, you know, there was no written contract. I mean, we can still win the case, that's not the point, but, you know, it costs more for every mistake you make to actually then prove it that you were right. So be careful.
Would be a situation like that if you went and you had a lawyer, wouldn't they, most people say, hey, give me 10 grand, 5 grand, and I'll let you do it.
Yeah, I mean, you know, you can always negotiate, tell them, you know.
There's always
At
that.
the end of the day, you wanna make money, let it go.
So let me ask you a question based on everything you've just said. If I make a complaint on Yelp, can he come after me for making a complaint against him? For all of the crap that he did?
You complain about it?
Well,
I don't know, if he's gonna sue you for defamation or other things, I don't know. If you tell the truth, there is no defamation. In fact,
Stay in court, let him
that's
sue you.
that's a affirmative defense against anything. If you are telling the truth, there is no defamation. But I don't know what your situation is, so I'm not giving you legal advice.
I understand what you're saying.
All right, let's go, move forward.
It's like you said, it's back home. It's a scam. If you're telling the truth, then.
It's a scam. I have heard so many people, be careful, protect it, maybe they do marketing well, do protect it, they don't protect anything good. Again, you have to file a trademark, no, as soon as you start using your trademark, you have a trademark. As soon as you're running your business, say, you know, you have a restaurant, okay? You start using your logo there, you start using your things there, you have a trademark. Let me just get this item. But there are reasons why you should, no, good, thank you. There are reasons why you should file a trademark, okay? Again, constructive notice, we've already talked about, applies throughout every intellectual property. But more important is the section of trademark law which talks about geography or your limitations. Trademark, the law is meant to promote business. So you have to look at the law in that sense. It's made to promote business. So if you are not going to go nationwide, you know, and it's a good thing for others to do, maybe they can do it in another jurisdiction. They don't have to come and tie up with you. But if you do decide you're aggressive about it, protect it. So for example, for a restaurant, there can be a really nice mom and pop shop in Hialeah, all right? People go there, local residents go there, once or twice, you know, somebody from Miami drives up there, but that's pretty much it. No one knows about it, it's not very well known, they never market it. And again, I'm giving an example, maybe real life example, there are more different facts, but just an example so you understand what it means. So now, a person is traveling from California, visits the Hialeah restaurant and says, wow, this is a great idea. I like it, I really like what they've done. Goes back to California, starts a restaurant, files a federal trademark on their name, on their trade dress, protects everything. Guess what? You don't have the Hialeah mom and pop and shop have no rights to go after him in any other jurisdiction other than Hialeah. That's where they're limited. Okay? Because they don't have a federal trademark. They may have a state trademark, I don't know what the name of the business is they ever registered. or they did DBA or whatever they did. But in theory, they may have superior rights. The second party cannot knock them out of ILEA. They're always gonna be senior party there. They're always gonna have senior rights in ILEA. But outside ILEA, if they try to do something, the guy is gonna sue them. They cannot go anywhere outside. So trademark has jurisdiction, a little more formed than copyright. Now you see how the law is kind of gets a little more technical as you progress. So this is not your common code anymore. I don't treat trademark as common code.
If you want to open like a Publix in California, could you do that?
Publix is not a good example. Be very careful dealing with big corporations. They have their own legal department. They do. Not a legal department, but I don't know if they have internal legals, but they have big firms that work for them. Anybody, any law firm would love to have a Publix as their client. So that's one example, all right? To file a federal trademark, you get protection in the entire US territory. Evidence of ownership, right? Again, you are the owner in terms of litigation or going after someone. Now the burden is on someone else. They have to prove me wrong. I don't have to establish, like you're saying, right? If you had a contract of assignment or something, now it's his job to prove you wrong. You already have your contract. You can just go and file a summary judgment and walk away from that. And plus get your damages from him for suing you for knowing and filing a frivolous lawsuit. Right? But evidence of ownership is a big deal. In litigation, it takes a lot of money away from you to spend and puts on the other guy. You spend and prove me wrong. I filed a trademark. Now tell me if I did something wrong, but you have to prove, not me. All right?
So, authors of literary works, it's customary for them to get trademarks if they think it's a commercial enterprise.
Well, authors is copyright.
So this may not be necessary if you have.
No.
Okay.
Unless you start a corporation, a publishing company, you want to register your name.
Thank you.
Jurisdiction, federal courts, I'm not gonna go deep, but it's advantageous to take a case to federal courts than the state courts. Yes.
Can you,
Sorry.
Go ahead,
oh,
go ahead, go ahead.
can you do a search on your own to find out if someone has a trademark?
Yeah, absolutely. Trademarks
What is-
website,
What's the
go
website?
to USP, I will actually give that link again. But
Okay.
it is USPTO, United States Patent Trademark Office. United States Patent and Trademark Office. So USPTO.gov. Yes. .com, somebody knows.
I'm using the Vitruvian Man as far as my logo is concerned.
Uh-huh.
And that's very old, that was trademark infringement.
Yeah, it's in public domain, a lot of people use it. Yes.
That's to see if they have a patent or trademark or.
Both, you can do patent search and trademark search. Only the copyright is a different website, copyright.gov.
So if I have somebody create a new website for me, drkaren.com, and I give them all the information, and I say, I want this here, there. Is it my website, even though I've had somebody else design it?
Again, you're going back to the same question. If somebody's writing your contents, designing your website, have a contract which says it will belong to me. How simple is that? You sleep easy at night, you don't have to bother about it. It's a very simple contract. The simplest contract can save you a lot of headache. Google it, you'll find a lot of templates.
Well, some websites you own them and some you lease them, so that's another question.
Yeah, well, different questions. If you own a website, they cannot take your domain, right? So
I'm talking about the actual
yeah,
content
she's
of
talking
the
about
website.
contents, and be very careful. Copyright infringement is huge in terms of online content. I'm trying to talk to this client of mine which has probably around 300 infringements, a big corporation. That's all they do is online content. Each infringement, the minimum damages I can ask on just the demand is around $2,000-3,000. You will pay. You will pay, otherwise there will be a lawsuit. So there is no excuse that, oh, somebody put that content in from me. Oh, I hired this guy in India, he did everything for me. No, that's not an excuse. You are going to pay the damages.
But she said she wrote it.
No, even if somebody else writes it, But that guy can now come back and say, hey, it's my content, I never gave it to you, I just leased it to you. So.
But I had all this stuff on on the hard drive,
Yeah,
and I sent it to the one who scanned to me, and then I have somebody else who's creating another website. But it is my intellectual information.
if it's yours, IP, it's yours, then you have no problem. But then if you had a contract, it would be.
The gentleman up front and I both have game boards.
Okay.
Okay, if we want to get a trademark, would the trademark be our actual game board?
Your name on the board, is
Oh,
that?
so it will be the name of that particular game would be the trademark?
Yeah, or
Okay.
you can have a big name and then subsets of different products that you launch under that name. Colgate is a big company, they have billions of trademarks.
Because I've seen other games and stuff, it'll have a little design like a logo or something and beneath it says trademark,
Yeah,
but that's different from the actual product.
you can in some cases actually send an actual physical object for the copyright. You're talking about copyright. You
Okay.
want to copyright the board, how it looks like. You can in some instances, I can, like the Mickey Mouse, there's an actual Mickey Mouse sitting in copyright archive.
Okay, but I'm speaking of trademarks. You know, like I said,
No, trademark is just the name of the business.
okay, just the name.
The protection for your board, how it looks like, if you take a picture of it, you can file a copyright on it.
Okay,
It's
okay,
not a
good.
trademark.
I got it.
Should you use TM after your logo?
You can, but that's a common law trademark, you have not filed a federal registry.
Oh, okay.
What was the question?
Can you put just a TM and use that as a trademark? Yeah, you can. Just TM, you know how, this superscript TM, or R in a circle.
After your name.
Yeah, or a C for copyrights, yes, you can do it. That generally means I have not filed a federal, I don't care, this is my trademark, I'm telling you, as soon as you see it, you see that sign.
But you have
There are
no,
disadvantages.
we have no legal recourse.
You do, no, absolutely, common law.
Geographically, limited
If
geographically,
it was
but not
online
federal,
and you can,
not nationally.
or if it was online,
Okay,
you can establish your presence in different jurisdictions you have.
okay.
But now the burden is on you, your attorney will have to get all this evidence, spend your dollars, waste it, and then all you had to do was to say, here's my trademark. You prove me wrong, right? Now you don't have to establish it. You see the difference? There's a lot of money that is involved in establishing something. Discovery stage of intellectual property and litigation is
So
very
basically
expensive.
what you're saying is that without registration, if you use TM or whatever it is, then the burden of proof is on you in case there is an infringement. But if you do register,
Okay. No,
then of course
common
the burden of the
right.
proof goes on to the other party if
Exactly.
you have been
Exactly.
given that
You are
particular-
now the senior party if you have a federal registered attorney. Think about this, right? How are you going to file a case in the court? Either you're going to attach a copy of your trademark, the federal trademark certificate, or you're going to write a whole lot of things that I did business there, and this, and there, this is my customer list, and blah, blah, blah. It starts getting expensive.
Can an individual file a pro se lawsuit against someone for
Absolutely.
trademark infringement?
Yeah.
And can they be
You
successful?
don't need attorney anyway.
You don't need an attorney
For
to
anything in
do
this
trademark
world.
infringement? Okay.
No, you don't need, period. But then, doctors have a profession for some reason, attorneys have a profession for some reason. I had a bad day this morning, I survived, I was in court. And I was standing there, and I was lost. I was like, what the hell is this guy talking about? What am I missing? And then I came back and I realized there was some other procedural issue that this guy was trying to trick me on.
Mm.
You will lose on procedure,
Yeah.
just the procedural part, not even facts. You will never get the facts. They will trick you in procedure.
Yeah, but doesn't the court make accommodations for someone who is not legally proficient?
Court hates procedure. Trust me.
Even in small claims?
Small things is fine. Do small money, man. No, but the thing is, there is a structure. It's not they hate it, there's a structure, right? It's like they will have to adapt to everyone who walks into the court, right? They don't do that. they cannot tell you, they're a referee. They're going to just say, okay, what you said and what you said, present your case and I'll be the judge. They're not going to sit in your case and be like, hey, do this. No, that's not their job. They are actually breaching their professional conduct if they did that. Now they're taking side of one party compared to the other. No sympathy. If you go pro se, you are an attorney as good as an attorney. So you may actually lose on a procedural. I did survive. This morning.
So the guy
I came back to my office and I found what I was doing.
Did he represent himself?
Yeah?
You said the guy represented himself, that you were against
No,
his
no,
own?
no, I'm a very seasoned attorney,
Oh, okay.
not a pro se. Yeah. Good. Any other questions?
I have a question about this. It says attorney will conduct trademark searches. If I wanted to use you as my attorney,
Yes.
to do a trade.
Oh, let me make another disclaimer. I am not selling any of my services.
I understand.
I am a SCORE volunteer. So don't use me as an example. Just
Okay,
use an
if any attorney, what does it normally cost? You mentioned a
I
$275.
don't give out costs, because my cost is my cost, everybody has a different scale. I can tell you what the government fees are.
Okay.
Searches, well, this is another aspect of it, I wasn't going into, you can conduct the search yourself. Go to USAPT.gov, there's one tab for trademark, one for patent. If you hover over the tab, there'll be a drop down. It says trademark search, and you can do your searches yourself. You don't have to hire an attorney, okay? But why this point is there, USPTO.gov. And trademark office.
Okay, yes, okay, I got it.
So what this point was about is other practical aspects. If you do hire an attorney, it's my ethical obligation to do my due diligence. I cannot rely on your word. You come up to me, you say, hey, this name is available, file a trademark. I can lose my license if that name was not available. But the good side of it is, you will save a lot of time and energy and effort if you just decided that doing the due diligence up front to make sure you're not building a goodwill 2-3 years down the line and then somebody files a lawsuit and says, stop using this name. Now what are you gonna do? Go back and tell everyone else over these 4 or 5 years who you build the relationship, hey, don't call me Divya anymore, call me Mac. You know, it just, my name is my name. It has some significance. I relate to it. You know, people relate to you with that name. So be careful in the start. Do your due diligence. You file a trademark. File it yourself. You just have to pay $275 or $325, I think, if you do a paperwork. But you can do it. All right. So
Can you include a number of trademarks under the 275 filing, or is it each trademark you have to pay 275?
each class,
Each class.
you have to pay $275.
So you can have multiple logos.
Even
or
with
stuff.
one logo, if you are covering t-shirts and perfumes, that's $275 plus $275.
Okay.
You can have one logo, but you pay for the class, because what trademark wants you to do, define what business you're doing, so that someone else can also do the business. They like that, right? It's all to promote the business. That's the motivation behind these laws.
So what if you have more than one logo for the same class?
Well, then you file 2 trademarks.
Okay.
But you choose one class. So now you're paying $275 for this and $275 for the other
So you
trademark.
can't do a catalog for a trademark.
Yeah.
Just asking.
You
Yeah.
can, but then you're gonna be very weak trademark, very weak trademark.
The renewal fees, they're like every 3 years, 5 years?
There is no renewal fee for copyrights. There is a renewal fee for trademark. And then there are some renewal fee for some type of patents not yet. Alright. Again, you know, you're gonna invest your time, do the initial aspect of it to protect yourself so that you can now sleep in peace and build a goodwill knowing that you've done your, at least some due diligence, alright? I'm not saying nobody can get sued. If nobody could get sued, I wouldn't have a job. Everybody can get sued, no matter how much due diligence you do. but it's good to have some than to not, okay? There's a lot that comes with it, a lot of peace of mind that comes with it, so do it.
Just a quick question.
Yes, sir.
I'm currently using my logo on ads on the internet and stuff like that, and I don't have a trademark, federal trademark. That means anyone out there on the internet can take my logo and use it and file a federal trademark?
That's different. Copyright you can protect.
But I
Trademark,
can't connect the trademark.
trademark, I have to see how you're using your mark.
Oh, shoot.
I
Okay.
know. They can use the mark for, instead of internet marketing, water sports. How are you gonna protect that? Alright, so what is trademark infringement? You can read all this. Blah, 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 blah. Well, what's the essence of? Like, similarity in overall impressions, similarity of goods, strength of plaintiff's mark, how distinguishable you are. If you just used an A, come on, do something more than A, just have A, B, C, D, something. Evidence of actual confusion. Intent, what was your intention? That's a very good legal rule about it. So there was a lawsuit, and the guy is on the witness stand, who's being sued for breaching the trademark. And the attorney goes up to him and he's like, okay, so what was your thought process when you were coming up with this logo? He said, oh, I saw their logo, and I said, that's really cool. I want to do something similar. And then he was like, oh, so your intention that you started your business with was to copy someone else's, piggyback on their logo. So don't say that. Proximity of goods, how, like if you go to a supermarket where they keep their goods, and if the supermarket classifies goods in degree of care likely exercised by a consumer. But the overall theme in this is likelihood of confusion. Okay? That's the overall theme for a consumer. A consumer can be a sophisticated consumer can be a dumb consumer. But the likelihood of confusion for a consumer is the god here. Consumer decides what happens. All right? Somebody who shops for vegetables is not considered a very sophisticated consumer. Someone who shops for high-end brands, Fendi, those purses, they're high-end consumers. They're more sophisticated consumers, right? So it all depends on the consumer. If the consumer can be confused, you got a lawsuit. If the consumer looks at your product and he says, oh, this may be the same thing, that's a lawsuit. Means you confused the consumer, and consumer can be qualified. The experienced consumer versus, and people have won lawsuits by saying, hey, this is a very experienced consumer. He will never confuse Fendi with my bag. Ask him, or her, probably. There are a lot of sexual orientation, so him can be a right thing too, but mostly females. They buy purses. So ask her. She'll be like, yeah, that's not Fendi. I know it. Hey, there you go. Dismiss. Judge, I need a default judgment. So you have no case because the consumer was not confused. Okay, consumer is God. In trademark, consumer is God. If the consumer can be confused, you got it. So, questions?
Well, counterfeit is criminal.
Counterfeit? Yeah.
Like the Fendi bag.
There are criminal legal claims. Oh, I don't know if I had this or I skipped over it, but if you have a trademark, you can always, your federal registered trademark, you can always register. After you get your federal registered trademark, you can take it and you can register with Border Security Protection Agency. Border Protection Agency, you can register with them. And if you do, the product with your trademark cannot come in. They will stop at the border. Customs, so Customs and Border Protection will stop the product, if there are shipments, and trust me, every day there are hundreds and thousands of products being held by customs because it is somebody else's trademark, it's not going to the official address where it's supposed to be.
So can they actually process your copyright or your trademark paperwork for you as well?
No, 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 you have to get a federal trademark, not copyright, trademark. And then you can go to Customs and Border Protection, CBP, and then tell them, hey, I have a federal, I don't want people to be bringing my, if the product comes and it's not going to this address, it's not mine. And they will stop. So that's another advantage. Sorry, that was the website for trademark, USAPatents.com. I generally go over the website, but I think I'm running way behind on today's schedule, so, but go over it. If you have questions, send me an email or something. One second.
So you can show them a patent, or trademark, or copyright to the Border Patrol?
Only trademark.
Only trademark?
Yes. Question was?
Yeah, Google has also a patent search. How different is that from the government?
Google, some cases is better, but it's still not comprehensive.
In what sense?
Well, generally I get membership for commercial databases, and that's more comprehensive.
Okay,
Google is
so-
still not as comprehensive. It's a little more easier to do the search on Google patents. But you cannot use like the Boolean logic in it. You can still use some form of logic in the US government's website. There are different, like you can search by number, you can search by name, just a simple, or you can do your own little Boolean. But the other databases are there. I don't know, you all know Reuters, right? Reuters has a database called Delphion, which is the best patent search software in the world.
Spell that website.
You don't need to know. It's way expensive. A lot of big firms don't buy it. Yes, very expensive, $50,000 a year. That's just the rent. All right, sir. I'll be your attorney whenever you need help, if you have that kind of money.
I have an interesting thing. My family is owned a printing business, and we used to publish maps, Rudolph maps. And one of the things is all the map companies, Rand McNally, Golf, they all use the same maps. They all use the U.S. government geodesic maps, okay? And then they artistically do it. And what they do is, on every map, they make 6 mistakes, and they copyright the mistakes. Did you know about that?
Yeah.
Yeah, I thought that was really very interesting.
Well, they don't want you to make it a copy.
Right.
So they will, how will they tell you if it's a government public map? They cannot.
Right.
So they do file a
Mistakes.
copyright with those mistakes in, and they say, these are mine.
Right.
The mistakes are mine. You
Right.
cannot make those mistakes.
One of the interesting things is a map of Pompano Beach. They wanted to they put in a road that doesn't exist.
Well, a lawsuit maybe, if somebody gets injured falling dead.
No,
That's
All right.
why GPS stuff.
Let's take a 5-minute quick break, and then I'll go over patents and trade secrets.
I want to ask you a question. This right here is a list of all the documents that I'd like to one of the things I've always wanted to do is one of the so my son made a spreadsheet, and I put in all, I have a now, the question is, I have hired you to what do I need to do to protect it?
Just want it beyond.
Make sure that they don't use this list for
You
something.
need to protect your trade secret.
How do you do that?
Tell them it's your trade secret, it's
Right.
list. I cannot have it.
Okay.
Well, I'm giving them a reason to use it, okay?
That's fine, but it's your list.
Yeah, I don't want them to use it for anybody else.
That's why I'm saying, you need to protect the trade secret. Licensing your trade secret.
And so I get them to sign a piece of paper that.
Yeah.
And that's it, and this is exactly.
Yes, the utility patents are 20 design of. That's what You have my card, if you have questions, please.
Yes,
take
sure.
it.